Good afternoon, dear colleagues. We're happy to greet you at our roundtable discussion, which will cover the most current urgent issues in labor laws that are becoming more and more important, both for the state, all the states in the world, and Russia as well. It has to do with the consequences we have to go through because of the crisis, because of the international global financial crisis, and the technology evolving makes certain issues in labor law more urgent, and we start to speak about the issues we've never touched upon. The problem of reforming labor law is paid a lot of attention to, and you've seen it in the Russian lawmaking, and the International Labour Organization also works a lot together with the state bodies, with the government bodies, and they're talking to the businesses, accepting various initiatives that could solve various demands of the business when they regulate their relationship with the personnel. I would like to introduce our speakers today. Lyubov Yeltsova, Deputy Labor Minister of the Russian Federation, Deputy Minister of Labor and Social Security of the Russian Federation. For 13 years, she has been working in the executive government bodies and has been making laws of the Russian Federation. Karin Varga, International Labour Organization. Ms. Varga is the head of the labor law division in the Department of the Trilateral Interaction of the International Labour Organization. Roman Kvitko, Gazprom Neft, is a director of the legal department, and he has unique experience in legal management, managing integration after contracts, after mergers, and maintaining relations with the government bodies. Our speakers from abroad, coming from Great Britain and France, Richard Miskela, Lewis Silkin firm from Great Britain. Richard is a partner of labor practice of the Lewis Silkin firm, and he's also the mediator, mediating labor disputes. My right hand, Pascal Logut, Capstan legal firm from France. Pascal is a founder and one of the founders of the company, and he's one of the founders of the Jus Laboris Alliance, bringing together law firms in various countries, firms that deal with labor law. Evgeny Reisman, a counselor for Baker and McKenzie Company, and chairman of the Labor Law Association in Russia, and he represents employers in one of the committees of the State Duma of the Russian Federation. Yulia Borozdna, Pepelev Group law firm, and she is a vice chairman of the Committee of European Business and Labor Law, and she is one of the leading experts in Russia, leading experts in labor law in Russia. And she is very active, working on and analyzing legislation and draft bills that are now being passed in Russia. We would like to start our discussion with a question I would like to address to Lyubov Yeltsova. How do you see modern trends in labor law? What are the most relevant and urgent issues and initiatives are being viewed, are being considered, and what issues would be of the most important, of the highest importance? Well, I've got a short presentation. Since we're short of time, I won't be able to describe a lot of legislative initiatives that we've been discussing and considering, but I'll try to say, well, to tell about the most interesting things. When we're talking about modern labor market and trends in labor market, from outside it looks fine. The registered unemployment rate is rather low. It's slightly over 1 million, and the job vacancies outnumber the number of unemployed. The number of the employees who are sent to leave, forced to stay out of work, is less than 200,000. In the future, we'll definitely see the reduction of the labor force, and we need to pay more attention to the growth of productivity of labor, and try to create conditions for training qualified personnel, skilled personnel. If we're talking about the challenges, we should number the following. The major problems are that the employers, when they enhance their production, they have to deal with the employees who are not qualified enough, who are not able to work with technology, with sophisticated technology, and they spend more time to adapt. They have to train them additionally, and it's very costly, and the costs are the training costs are high. The costs for new corporate systems are rather high. For employees as well, they're not qualified enough, they're not skilled enough, and they become less competitive in the labor market. And the wages are, the level of wages is also relatively low. So to create conditions to bridge this quality gap between supply and demand in the labor market, over the last half of 6 months, we've done a quality breakthrough in creating regulations and norms. We have introduced an article into the labor code of the Russian Federation speaking about the new system of professional standards. And when developing this article, we have issued a number of documents that allow us to start working together with the employers and the trade unions to start to form a new system of qualifications, professional standards. The new law on education that will come into force on September the 1st, 2013, already provides for the educational standards to comply with the professional standards. And we hope that it will allow us to make this relationship between the labor market demands and our system of education more relevant, more important. In the labor code of the Russian Federation, we provide the basis for the professional standards to replace in the future the existing norms and existing the norms we had for over 20 years. In the future, we'll have about 800 new professional standards developed on the federal level. In the future, they will replace 8,000 qualifications we used to have previously. And it's a very, very important, very serious task, and I wouldn't limit ourselves to 2 years. It doesn't mean we will be able to replace the old normative base in 2 years. We have to be very careful. Legally, in the labor code, we stipulate that the qualifications that ensure benefits, the employer must write down to their must fix it and write it down to ensure those benefits. So they have to be very careful when naming these qualifications, not only legally, not only providing for economic, but also providing for the legal compliance. So this work will require expert community, and I would also like to say that as the system, I mean this professional standard system, we already have a group that works on it, and what have we encountered? This mechanism that was suggested by the expert community, by the employers, that the employers, first of all, must be very active, should initiate those standards to be developed. Unfortunately, since the beginning of this year, when we started to work on these standards project, unfortunately, we saw that the employers were not very active. And we understand that the role of the state is very important in this sense. The state must be more active, and that is what we are doing now. We hope that we'll rely on the state to develop those professional standards. What have we used from the international experience? In the Russian Federation, we have a Russian register for qualifications, and it's a bit outdated. We have a new register, qualification register. We're now providing a new version of this register, which will come into force in June next year. All these are standards I would like to show. I mean, I'm going through my presentation very quick. We have certain groups, classification groups, about 800 groups. We used the Russian classification code, and we used also the tax classification and other types of classifications, educational classification codes. So we managed to provide 800 professional standards. Now we're in discussion with registration bodies, and we have announced a tender for the professional standard development. By the end of this year, we plan to have at least 300 professional standards developed. How do experts participate in this work? The Labor Ministry of Russia runs an expert council in which stakeholders, all the stakeholders take part, including trade unions, expert community, educational establishments. We have very few officials, which was always perceived as negative, because if we have few officials developing those professional standards, it will be bad for the business and for the employees as well. So those institutional basis has been formed, and now we need to, all the stakeholders need to move towards the new professional standard classification code. Moreover, I think that for the Russian Federation, it's most important to have to educate, because we see that not all enterprises, especially the small business, especially the middle-sized business, they don't understand the necessity of these standards. They don't understand how they can apply those standards, because and they don't understand how these standards would improve their production. And what is most important, is of paramount importance, is to educate the employees, to explain it to the employees how they can use these standards. And this is what we're going to do. And we should introduce those professional standards and apply them and make people use them. And it's a very important and difficult task for the Russian Federation. It will take definitely more than 2 years. It would be very important for us to hear about the experience our international colleagues can offer, and the International Labour Organization. It would be interesting to know how these problems evolve in other countries and how they're solved in other countries. I would also like to draw your attention to the following initiatives that are very important, and they can change the approaches in the labor code that have to do with ranking and assessment, which is very important for the employers. At present, the mechanism of assessment is criticized by the business community. Now we're working on the new draft. We're drafting a law which has to do with the modernization of this mechanism of performance review, of assessment, and also assessing jobs with dangerous conditions, with dangerous labor conditions. The mechanism will not only assess the jobs, but also assess the provisions for the employers, security provisions, safety provisions. It will influence the tariffs, the wages, and especially for the enterprises, especially for the companies that have dangerous jobs. Some additional percentage for wages for the employees working at dangerous jobs is, and then at present the companies will have to pay plus 2% to the wages to create comfortable tax conditions for the enterprises that tend to reduce the number of dangerous jobs. It will be a very efficient economic mechanism. It will take into consideration all the measures that employers take to reduce the danger. Another innovation, and the law has already been enforced. It has to do with distance employment, remote employment. In Russian Federation, with a relatively low rate of unemployment, we face regional disproportions. In southern regions, you have areas when you have 20 applicants for a job, for a vacancy, and in the Far East, where labor resources are scarce. And if we create a flexible form of employment, when you can use your electronic signature to sign contracts, of course, it's mostly for white-collar workers, but it's a chance to get additional employment and to to sign, to conclude contracts with employers who work in different regions. In other regions, it can be in the central region, and an employee can be working for them, still living in the south of the country or in the Far East. I would also like to speak about rights protection for the employees in case of bankruptcy. Over 2 billion rubles. We have over 2 billion ruble debts in wages, and the sum remains the same. About 3% of the sum goes to the enterprises that are undergoing bankruptcy. And we have amendments to the law, to the bankruptcy law, and we're working on the subject. It's not a new issue, and we're working on an issue how to create state government guarantees to provide for the rights of the employees when the enterprise does not have assets to pay the wages. It's a very complex topic, and there'll be a heated discussion among the experts and the employers. But I mean, we're working on it. Since I'm short of time, I won't be able to tell you more, but we have a lot of initiatives. Thank you for your attention. Thank you, Ms. Yeltsova, for the interesting piece of information. We, as practicing lawyers, we see it as a positive. I mean, we see these changes to be very positive, especially concerning the distance labor. It's a novelty in our labor law, and thank you for being so active in legislation, and helps the dialogue between the business, between the state and the society. My next question would be addressed to the International Labour Organization, represented by Karin Varga. What do you think? When you analyze global trends in the labor market, in general, what trends do you see in various countries in the current economic situation? Maybe you will be able to share the initiatives taken by the International Labour Organization to overcome the consequences of the global recession.
Yeah, I think. Thank you, Irina. And let me first, at the beginning, thank you and the organizers for having invited the ILO to this International Legal Forum, which is an impressive event. Now, addressing your big question, I've prepared here a few slides just to support my sharing of this global perspective on what labor law reforms are we witnessing worldwide. First, it's very clear that globalization and the crisis have been two phenomena that have been driving legal reforms throughout all regions of the world. Labor market reforms are typically driven by a number of factors and issues, and are aimed at addressing a number of challenges which I've put up there, the first of which is low employment growth. Low employment growth really push governments to put in place programs and adopt measures to promote employment creation, and this has direct implication in terms of labor law in the area of hiring and firing. Also, another challenge governments have to be addressing is increased competitiveness pressure on enterprises. Enterprises have typically to be competitive on four main factors. Price, certainly one. This leads us to discussing wage and wage level and productivity, but also timely delivery, quality of the product, and last but certainly not least, socially responsible production. The latest incident in Bangladesh, I'm sure you all heard about this garment factory collapsing in Bangladesh. And the very quick response of some major brands that included Zara, Carrefour, H&M, just to cite a few, just illustrate the importance of that competitiveness factor also in globalized economy and in certain supply chain areas, and the importance for employers not to overlook that competitiveness factor. Then last, growing inequalities. This is really a phenomenon that's requiring the urgent attention of many governments in the world. This is especially true because it's leading to social unrest and political instability in many parts of the world. Arab Spring is just one testimony of this. And we also, many countries are witnessing extremely alarming youth unemployment rate. And this triggers actually also a number of reform, mainly directed to facilitate school-to-work transition from young people and also access to first employment. And then last but not least, rise in labor disputes, be them individual labor disputes or also collective. So when this is really the context in which these reforms are taking place, and typically the main reform areas when it comes to labor law and labor market reforms include employment protection legislation, hiring and firing measures, and they're typically issues that are being re-regulated are fixed-term contract, temporary agency work, procedural requirements for collective dismissal, severance pay, and then also notice period and probationary period. This is something we observe in a big number of countries. Another big area of changes is around collective bargaining and the procedures for collective bargaining, the criteria for determining who is representative and at which level. Another specific area on which, especially in Europe, we've seen a lot of reform is the content and the level of collective bargaining. But I'll come to this in a moment. This is the result of a study we've done of 144 countries throughout the world. And actually, out of these 144 countries, 76 did revise either their employment protection legislation, hiring, firing regulation, or their collective bargaining regulation, or their dispute settlement rules. Now, if we're zooming a bit more closely at employment protection legislation reforms, I mean, this table is trying to capture sort of a worldwide trends. And it's really interesting for one main reason, because it's really telling you that the situation is complex. The trends is not pointing to in one linear direction, be it either flexibilization or reinforcement of protection. You see in blue, this is the countries that have revised, and you've seen it there too, but I'm using that one. It's more easy for me. In blue, you see actually changes that were meant to reduce workers' protection or ensuring more flexible employment relations. And in red, changes that were leading to a reinforcement of workers' protection. And you can see that actually often what we witness is reform in a given country would do both things at the same time. So it's really important to bear this in mind, not to draw hasty conclusion as to what are the real trends in terms of reforms in the world. Another interesting fact about this slide is that it shows you the tendency per region. Obviously, there has been a wave of reform in in European countries in the area of employment protection legislation, and this is really part of the labor market reforms implemented by European member countries in the context of austerity measures. If we, given the time, I'm not going to be able to enter into many of the details, but let me just give you a few pointers. Changes that affected regulation of termination of permanent employees. What we see is changes affecting the use and the duration of probationary period, extended valid grounds for dismissal were also introduced in a number of European countries. With respect to notice period in advance of dismissal, there really the tendency is really mixed. A number of countries reduced the notice period, including Armenia, Estonia, Greece, Spain, Slovakia. Belgium equalized the notice period between white and blue collars, and Montenegro, Romania increased the notice period. With respect to severance pay, 7 countries reduced the level of severance pay in Europe, and 1 extended it. We also observing some increased protection against dismissal based on discriminatory grounds. With respect to collective dismissal, actually 14 European countries revised their labor legislation, 9 decreased the level of protection, while actually 4 introduced new rules, mainly in relation to consultation and information of workers before collective dismissal. And there, actually, I just want to highlight that this is a case in Belgium, Ireland, the Netherlands, and UK, and perhaps you're going to touch a bit on that later on. Then last, changes affecting fixed-term contracts. Mainly, actually, it's to facilitate the recourse to fixed-term contracts. Collective bargaining changes. This is also telling you that the story goes in many different directions. 2 regions are interesting. Asia, where actually the changes were mainly meant to facilitate and promote collective bargaining, and Europe, where we have a slightly different story, where mainly the reforms were pushing towards more decentralized collective bargaining taking place at the enterprise level, and in many countries actually allowing enterprise-level bargaining collective agreements to derogate from higher-level collective bargaining. I have much more to say, but I'll stop there.
But would you probably say a couple of words about initiatives of ILO, if possible?
Yeah, no, I will. And actually, I want also to say a few things before that on labor dispute prevention, because this is also an important issue in the context of these labor market reforms. What we're seeing in times of crisis or rapid changes is that labor conflicts are on the rise, be them individual or collective, and a number of countries have actually adjusted their regulation to ensure better functioning of their dispute settlement mechanism. This is the case in many countries, and actually these reforms are trying to address what I've been listing there, the most frequent shortcomings or dysfunctionment area of labor dispute mechanism: lack of independence and accountability, cost and delays due to under-resourced either labor administration system or labor justice institution, burdensome procedures, ineffective remedies. I'm sure this is going to speak to you as we witness these problems all over the world. There is no one single country that's not faced with one of these challenges. And the key trends in reforms are that we've been identified, and these are going to be discussed next June. We have a big international labor conference held every June in Geneva, and we're going to have a discussion on dispute resolution mechanism and trends of reforms. And the report that we prepared for this discussion highlighted these trends in reforms. Some countries either creating or strengthening specialized tribunals or courts. Some are improving their conciliation or mediation or arbitration systems. Some are establishing special proceedings for dealing with disputes related to freedom of association or collective bargaining. A number of countries are reforming their rules, and I know this is the case in France, and we may be hearing of this a bit later on in terms of the time frame and the procedures and the length of procedures for handling disputes. Then one last thing I want to highlight on that slide is the creation of statutory advisory services to help prevent the escalation of conciliation disputes. This is really an innovative initiative that we're seeing in a number of countries, including UK, and perhaps you're going to say a few things, but very recently the arbitration, ACAS, the Arbitration Consultative and
the Arbitration Conciliation
Service of Britain is going to be called upon to provide guidance on how to run consultation before collective redundancy. And this is really interesting because it's in the interest of everyone actually to have smooth management of collective redundancy. Now your question about what is it that we're doing. We're doing many things. But to address more specifically the crisis and the austerity measures, actually these are initiatives taken at the highest level of the organization. And very recently we had a regional conference in Oslo where all European countries met. And when in the ILO we meet not only with governments, but we meet with employers' representatives and with trade unions. And as a result, they've adopted a declaration which actually is spelling out the wide range of issues and activities the office needs to be running to ensure that actually all these austerity measures and programs are leading to job growth and quality recovery from the crisis. But turning now more specifically to the subject that's interesting as labor law and collective bargaining dispute resolution, we're providing advisory services to member states that are revising their labor legislation. We do handle 20 requests per year of countries coming to the ILO. Very recently, we've been engaged with Russia on this initiative to regulate agency work. A delegation from the State Duma came to Geneva. We engaged in discussion with them. We introduced them to the guidance coming out from the International Labour Convention on Private Employment Agency, Convention 181, but also using comparative expertise, comparative best practices. We came also to participate in a tripartite discussion in Moscow last December, and then we provided written comments on the draft legislation. And next week we're going to welcome again a delegation from the state who want to engage. So we're really engaging in policy dialogue, and we're doing tons of many things, but I think I'll stop there.
Спасибо большое, Карин.
Thank you very much, Karine. It's a pleasure to hear that you take an active part in issues around the Russian legislation as well. And from this perspective, let me ask this question to Roman. Roman, as we know, Gazprom Neft often deals with issues around the fact that your personnel has got to be mobile. What issues, challenges do you face in practice, and how do you tackle them based on the existing labor legislation? Maybe you could share your experiences and your considerations that could be considered as an addition to our labor regulation. Thank you, Irina. I am particularly glad to see representatives of the Ministry of Labor attending our conference here today, foreign representatives from law firms and international organizations. This may help attract attention to the issues that we've been facing recently. I mean, major Russian companies and expanding business. Many companies have gone overseas. We've done the same. That's something I'd like to share with you, the issues we faced. What issues do we face in acquiring a business abroad, for instance? Like myself, for example, we acquired an oil company in Serbia, and about 100 people were sent there, like seconded, and to bring the company to the group standards in Gazprom. All that mission took a couple of years, or 3 years for other people. So this is a specific example of what happens in practice, what takes place and what the needs are. There's a similar story, well, if you take any other joint venture. Well, joint ventures in the oil industry have become a trend, or a fashionable rule, and it is difficult for companies to take big risks associated with oil production. That's why they're setting up joint ventures, consortiums, and normally such joint venture terms include the replacement of positions or positions being filled by one shareholder or the other. And the team from one organization kind of goes and works in the other. What other examples can I give you? Imagine you have a need in somewhere in Siberia to enhance your finance function, and you send people, some strong finance people from St. Petersburg. There's a need to rotate people, to develop people, like say we start a project in Equatorial Guinea, then people move to Khanty-Mansiysk, then return to the head office. Well, these are the challenges or the needs that our business faces. What did you say? Which button to press? Oh, okay. How I would characterize the people that that are in demand, the so-called mobile staff, if you take the language of our HR people. Now, to describe these people who can very quickly, with no red tape, move between projects and countries, to develop companies' business in across regions, help implement quality standards and corporate culture. Well, big button doesn't help. Okay, this is one example that illustrates how this looks like. Bottom line is that Russian law has very limited mechanisms like business trip, travel, and transfer of people from one organization to the other, or dismiss from one organization and hire in the other. Well, business trip is good because the person keeps its job with all the social benefits. You don't have to ask his acceptance, but the minuses are that de facto you're being sent or seconded to a subsidiary or a branch for the purposes of that local organization, but that may not be in line with the tax code. So there are associated tax risks. And then a person may not be on staff, and if you're not on staff, you cannot have administrative relations with the company, which means you cannot give instructions or take instructions. Well, with all the associated problems. Like, suppose de facto you are a CFO, but you don't have the right to sign documents. So you take a hazardous facility, suppose the Omsk refinery, and you are a manager of a production unit. There's an explosion. followed by an investigation. Something was done wrong. A valve was not closed as required. Then I took the instruction from that person. So the question could be, why did you take the instructions of a person who's not supposed to give you instructions? And if you take travel abroad, then there's the risk of taxes. Well, I gave you the example of Serbia. 3 years in Serbia. Can you do that? Can you send someone for 3 years to Serbia? I don't think so. There are limits in the legislation. And then in the future, people during business travel, well, that period is not taken into account when in the calculation of average income for the person. Then combining two jobs at the same time, and there are limitations here as well, according to our law, because you can only spend a certain percentage of your time working on a second job. And then there's one other thing to well, usually the problem is that when you're on a business trip, you may have a very high salary. So if your salary is high, then in that region you're not in the percentile or whatever it's called. So again, this is about labor risks. In addition, you lose your social benefits because different entities have different benefits, and if that's overseas, like Equatorial Guinea, not everyone here will probably be willing to go there or even knows what the social benefits there are. Then dismissal is obvious. The associated risk is that the person has no guarantee he will be hired back. And people here are willing to take the risk going somewhere, but they want to come back. They don't want to stay in Equatorial Guinea to get lost in the desert or wherever, And then this draft bill that went through the second reading on April the 6th, it went through the second reading. It includes some positive changes in this respect, like the ability to second people from the head office to the subsidiaries. However, only up to a period of 9 months, and with a number of other limitations. So the issue remains outstanding. To sum up, what we could propose as a business facing these problems, these business needs, is to introduce a special regulation for mobile staff, to establish such a category of personnel. The features would be enabling companies, receiving host companies to receive the personnel, then financial liability of the seconded people for any potential damage, that is quasi-labor relations, and temporary nature of employment, because such people are usually hired to develop the business for 2-3 years, but then we wouldn't want to see the problem of there being nothing to do with the person. Then labor contracts should include the following elements, like Russian legislation doesn't make it possible what exists elsewhere in the world. Correct me if I'm wrong. The term net compensation which means that the person should be guaranteed that suppose he will get paid 100 rubles despite any taxes or whatever can be applied to his revenues. Why is that? When you've worked abroad, well, the tax regime is different abroad. It may not be 13% like in Russia, but 22%. So you lose, right? Then when you come back, if you spend 183% abroad, you have to pay 30%. So the current legislation doesn't enable us to compensate that, to reimburse that. So what we do, we pay out bonuses. But as you know, bonuses, by definition, should be based on particular specific achievements. This is the wrong way of doing it. You got to have the opportunity to reimburse these costs to the person, so that their net income remains the same. Then base salary should be defined, and then all other factors should be based on that. Added to the base salary, like for the willingness to go anywhere at any time, like Equatorial Guinea. Then reimbursement of tax costs, and then compensation for the geographical location. Like I mean, France can be perceived better than the Arctic, for example. And then what needs to be changed in the legislation, we believe that we need to legalize the relations between several employers and the employees. Then contracts between groups of people, or with groups of people, because what happens now is that the head entity has contracts with the controlled, or head office and subsidiaries. They need to be able to move people between them. Then establish the opportunity for entities to make contract seconding and seconded. Like, I mean, if you send a person to Khanty-Mansiysk to work, then the sending organization is supposed to pay everything he's supposed to get. If that doesn't happen, then the main company assumes the liability to pay, so that the employee receives whatever he's supposed to get. Plus, well, I won't list everything here, but the critical thing is to introduce this new definition of a one-off acceptance by the employee for this one-time relocation for a limited period of time. This is important for us. And then, essentially, include the opportunity for the receiving party to demand that the employment contract is complied with, or the way they say it in English, enforce the employment terms and conditions, even though that party is not an employer. And then exclude the opportunity to take them as a constant fixed-term contracts. Like, you know, if he's spending 3 years there, then any court will accept him as a permanent employee, which is not really right. So I'd like to also hear what colleagues would say. Well, thank you. I would like to propose the audience to formulate your questions by the end of this session. And now Roman has raised issues characteristic of your sector, the oil industry. Similar difficulties apparently exist in other business sectors. I would now like to address our foreign colleagues and ask them how these issues, particularly those discussed widely in Russia, the prohibition of agency work. How is this regulated in the UK, for example? Or it would be nice to know, are there any limits to agency work in the UK? Richard, if possible, could you share your perspective of the trends on the labor market in the area of labor legislation in the UK today?
Thank you very much, Irina, and I'm delighted to take part in this discussion. In terms of trends in the UK, to deal with that big issue first, it's fascinating to listen to my colleagues on the panel because we are in exactly the same situation. We're facing the same problems. We've run out of money. We want to employ more people. We want to increase productivity. How are we doing that in the UK? Well, the government that came into power in 2010 declared war on red tape, so regulation. And
Switch it on. Just
this one? Yeah.
no, that one.
This one? This. It's on. Sorry, can you hear me okay? Yeah. Okay, right, thanks. So the UK government in 2010 declared war on red tape or regulation. And what they identified was that there were 23,000 different types of regulation which UK employers had to deal with. So they have decided to try and sweep away as much of that as possible. And the idea of that is to try and give more confidence to small businesses, which we perceive in our country as being the true engine of growth and productivity, employers of under 10 staff, to try and give them the confidence and the clarity to employ new people. So the ways that we have sought to do that and what we're trying to promote very much echoes what Corinne's talk identified. So we are sweeping away lots of employment protection and delaying the point at which you actually accrue basic employment rights. We are changing the rules around collective consultation. In the UK, we have the apparatus of collective consultation without the real substance. So what we're doing now is we're reducing the form as well as ignoring the substance in order to make it much more easy for people to dismiss more than 100 staff if they need to. We're also changing our rules around the employment protections that apply when businesses are bought and sold. The Acquired Rights Directive, which applies across Europe, we are watering that down in the UK to make that less difficult for people to deal with. We are also making it harder for people to make claims in the specialist employment courts, the employment tribunals. In future, as well as having less rights, people will have to pay in order to make their claims, and they will also be liable for costs if they make a claim which fails or which is frivolous. At the moment, they don't face those concerns. And what the government is trying to do there is, on the one hand, to defray the cost of the tribunal system, but also to deter claimants from actually using it. And that will hopefully, in their view, save the government money, as well as reducing the amount of litigation that employers face in the UK. And if you're going to do that, there is a problem with access to justice. And as Corinne has mentioned, we are trying to promote alternative dispute resolution mechanisms so that we are not solely focused on litigation and the court and tribunal system. So there is a huge focus now on mediation, private mediations, judicial mediations through the court system, and also conciliation through ACAS, which is a government-sponsored arbitration and conciliation service in the UK. The big question for us is where we're going to get the money from to pay the government ACAS system to work as well as it will need to when people don't have the same access to justice as they did previously. In terms of agency work is a huge area in the UK. And it does help with the flexibility of our labour market. Agencies are not primarily something to be feared because they will take a lot of the administrative burden off employers. They will vet candidates, they will have ready access to an instant pool of talented people able to deal with the business's problems. But they have come under a lot of scrutiny in recent years because there are some terribly unfair practices which have led to what we would call a two-tier workforce. So the permanent employed staff have a range of high pay and benefits, but the agency staff don't benefit from any of those things. So 18 months ago, we introduced new rules whereby on day one of agency work, the agency worker is entitled to access to all the same facilities as permanent employees. And they're also entitled to have access to any vacancy lists that exist. And if they remain working in the same organisation for 12 weeks, then on the 12th week, they have the right to the same pay and conditions as if they were permanently employed. So that's not just basic salary, but it includes bonus, commission, benefits, you name it, they're equalised. And so that has inspired considerable ingenuity on employers' part to try and find ways of saying that agency staff are not truly comparable to the permanent staff. And just the final comment that I would make is that only 4 weeks ago we closed a major consultation with our government about ways of reforming the agency system further, because one problem we have is that the status of agency workers is not clear. So sometimes unfortunate agency workers can fall between two parties. So the agency does not accept responsibility of paying them, and neither does the end user. So those regulations are intended to close that gap so that agency workers have certainty and they won't be exploited.
Thank you, Richard. That's very interesting to know. May I ask you the same question to Pascal? What are the current trends on the labor law market in France, and what kind of regulation do you have with respect to agency work?
It's a very hot topic now because, as you know, we are living quite a revolution in France on two steps, another one, a new one. So, as you know, in France, since Napoleon, we still believe that nothing could happen without the state. So we do believe in the state. We do believe for years that the state will make all the regulation within the company and so on. And so now we are living a big change. The new government asked the unions and the company association to set up an agreement. This agreement was found, the new government says in the middle of last year, you have 6 months to find an agreement. If you do not find an agreement, we will set up a law. And so, as by a kind of miracle, at the end of the year, the company association and the unions find an agreement, not before the end of December, but on the 11th of January, because the unions say, no, we don't want to be under the pressure of the government. We want to bargain on our rhythm. And so they find an agreement on the 11th of January. And now the law will be implemented on the 1st of July. What does this new law say? This new law says if a company is facing difficulties, economic difficulties, and want to avoid the dismissal, the company could decrease the wages of the employee, increase the working time without compensation for at least for a maximum of 2 years. So you could decrease the wages, increase the working times. And if the employee do not accept that, so an employee on his own could refuse that, so he has to leave the company and he will get only these dismissal indemnities. That's all. So he can leave the company, but he could not, and so the company will not have to implement a dismissal, an economic dismissal. It will be dismissed for individual reasons. Of course, this must be organized through an agreement with the unions. But if you find this agreement, and this law was based on a global, on a national-wide agreement, so we can expect that the union will sign this kind of agreement on the ground. We the new law state also that if you want to dismiss 100 employees, it will the time frame for this will be no longer than 2 months. You have to know that now in the current labor code, if you want to dismiss 100 employees, the labor code say it will take 45 days. In the real life, it takes 6 months. Between 4 to 6 months. So the new law say it will take no longer than 2 months, and you will be sure that everybody will be out after those 2 months. So it's important things. Huh? It's very, very important, and it's a way to improve the competitiveness of the country and to improve the flexibility, and more than that, the safetiness of those processes, because for now, all the unions, all the worker council were used to sue the company, and they were very successful in front of the court. So the purpose of this new law is to improve the safetiness of this process and to be sure when a company starts a dismissal plan, they will end and the people will leave. Of course, if you find an agreement, it will be good. The new law also states that the judge, we change the judge, so it will not, the new law set up a new judges who will be specialized and skilled to assess the economic difficulties of a company and to assess if there is a way to slow down the process or not, but the time frame will remain the same. The new law also states that you can force an employee to move from a location to another one. And if he refuses, he will have to leave the company. So you could move, if you have economic difficulties, and you have a plant in Marseille, for example, and another one in Paris, you have room to welcome this employee in Paris. It is in Marseille. It's the south of France, sunny place. He doesn't want to move. Okay, you don't want to move, you leave the company. And this is based on an agreement signed with the unions. You could also force the employee to move to another position, even if they remain within the same location. Let's say you need engineer in this field of activity, and you have too much support in another activity. You could force the employee. Of course, you have to train him, but you could force him to move to the new position, to another position, and he cannot refuse. Of course, to implement this, you need to have an agreement. The national-wide agreements say that the compensation for the employee will be less. It will be costly for the employee to have temps within the company, because temps is seen as precare, as a precare position, so it will be costly for the company to have those temps. If you have part-time worker, you have to provide them guarantee. You could not have a part-time worker for less than 25 hours a week. So these are the compensation given to the unions to get this national wide agreement signature. And then, if you want to sign this agreement on the ground within your company, you have to promise the employee then at the end, if your company recover a good health economic situation, a good economic situation, you will have to share the profit of this recovery with the employee. So you can sign, during the implementation of the agreement, you could move the employee, you could decrease the wages, you could increase the working times without compensation. But at the end, if due to, of course, you will avoid dismissal, so those people will not be dismissed because they will keep their position, but with lower wages, working more. But at the end, after 2 years, if the company is getting better, you will have to share the benefits, the profits of those efforts with them. As you see, it's really a big revolution. But as you know, the French economic situation is very bad for now, so we have to take measures. And the important thing is of course, the outcome of this negotiation, but the fact that the unions and the company association accept to bargain on that, and that they exchange compensation to reach this agreement, which now will be implemented on the 1st of July. So for now, it's a kind of revolution for the French company, and which will, of course, bring a lot of work for employment lawyers on both sides, on the worker council side, on union side, and of course on the company side.
Thank you, Pascal.
The next question is for Mr. Reisman. This is about the law on agency work. I understand that you are working very actively in the work group that is working on that law. And I wanted to ask you, and I think it would be interesting for the audience to hear, what do your customers think, how the passing of the law, which has passed through its second reading, would influence the activity of Russian and international clients who have business in Russia. Thank you very much. Our clients are major Russian and transnational corporations where very temperate people work, and of course they won't hurl themselves from the Eiffel Tower or from the Empire State Building after this law is passed. But our counteragents tell us that this legislation does not increase the convenience of doing business in Russia. It will be less convenient, and perhaps some of the projects will be discarded, especially those that require major investments, whose economic effect is not clear, and these projects will be limited, delayed, or scrapped. No one is making a big tragedy out of that. So nobody says we'll leave everything and leave Russia immediately. But the convenience of doing business in Russia, the investment appeal will be lower. This is the opinion that's been conveyed to us. Thank you. I want to ask the same question to Yulia, to Ms. Borozna. What is your opinion of the legislation that's being discussed? Ladies and gentlemen, good afternoon. Our clients, they are also major Russian companies, major international companies. They're also wary about the passing of this legislation in second version, second reading. We're happy that in the second reading this law was reworked and amended. Now, agency work is not prohibited completely. However, the formulations of some of the statements in the law will limit the businesses in using these useful forms of structuring the workforce and the use of the workforce. I wanted to draw your attention to the fact that these mechanisms are very important for a company, especially in conditions of economic difficulties, because it enables the companies to be flexible about their employees and their staff. They can use not just agency staff, but also the seconded staff, as our colleagues from Gazprom Oil were saying. So this is a very important layer of relations which we have to regulate, which we have to legislate to lower the risks of abuse on the side of employers who are not good faith employers. But at the same time, you don't have to narrow the limits of the businesses, because that would really limit their possibilities, especially in the conditions of an economic crisis. I also wanted to point out that the last version of the legislation can be hardly used towards certain civil relations. For example, the use of drivers, of the work of drivers, of hairdressers. Somebody is doing something under the direct management of a client. And within this law, within this legislation, this activity can be considered agency work, which is directly banned. So it's wonderful that agency work in certain cases is allowed, but we would like to see the development of this legislation so that businesses would have better opportunities to use it. Thank you. Do you see any other additional issues that could be discussed, or maybe discussed together with this legislation? What is the perspectives of the further development of labor law in Russia? Well, actually, the Russian labor law right now is so obsolete and so inflexible. I was glad to hear today about the positive changes happening in France. Very revolutionary indeed. And we can only hope that Russia will reach that level one day. Russian labor laws are extremely inflexible, in our opinion. The employees are protected too much, which is basically limiting the opportunities of the employers. They cannot be flexible in reacting to economic change. They cannot regulate not just the number, but the quality of the employees. It's very difficult to fire an inefficient employee. It's difficult to provide benefits for efficient employees, because we also have certain non-discrimination clauses. We do need to move the emphasis towards more flexibility for employers. And there are a few things I wanted to point out. It would make sense to lower imperative regulations and to let parties to the labor agreement make decisions for themselves. For example, the notice time, the separation package. Now the rules are the same for everyone, for the managers as well, and I think more leeway could be beneficial. It's necessary to move towards more variability in labor laws and set different levels of regulations for major and minor companies, because minor companies have to be more flexible and more freedom, and to lower the red tape level. Small business is the engine of economic development of our country, and right now they're in very difficult conditions because of the amount of guarantees and compensations and red tape that they have to deal with. We think that today it's necessary to think in more detail about the strikes organizations, and to impose administrative sanctions if the unions abuse or violate the laws. Right now, the unions are not responsible for any activity that they organize. If the strike is considered illegal, there are no measures to hold the unions liable, which is a path to abuse. Also, we would like to voice the position of the business regarding the regulations regarding harmful and dangerous working environment as regards compensations and benefits. It's very good that the state is trying to stimulate employers to provide a safe environment, to have certification and so on. But it's also necessary to have some kind of differentiation regarding the scope of guarantees. If the company has certain harmful or dangerous working environment, because right now it's very uniform. If for example the lighting in the office is insufficient, or if it's something very dangerous, it's the same with a 4% bump, additional holiday days, and so on. So this is a very uniform approach to harmful and dangerous conditions, which is, I think, very unfair. We're working a lot with various legal trials with labor disputes, and we see that the employers suffer a lot because the trials are too long. The judges use a very formalized, very formal approach. And it's the primate of form over matter. If an employee is in serious violation, if the employee according to some formal rules does not fall under the tenets of the labor law, if the review was longer than 1 month, for example, and so on. So the employer cannot hold the employee liable, even if this employee has harmed the company a lot financially. So we have to shift the emphasis from the form to the matter. The most important thing is to analyze whether a violation occurred, whether the employee was guilty of that. Of course, you need to stick to the procedure, but it doesn't have to be so formalized. Finally, quite often the employees abuse their right to recourse to the courts for court-assisted settlement of labor disputes, because right now the employee is not liable to compensate the company for incurred costs, and so one of our customers, for example, had 5 trials with just 1 employee, and then we received another 11 claims regarding similar issues. We'll be dealing with that, but we're not able to apply strict measures to employees who are not working in good faith. It's still ongoing. To decrease the burden of the court system, it's very good to popularize mediation and other out-of-court settlement venues. The law on mediation was passed 2 years ago, but it's still very it's still in almost unused. While this is a wonderful method of peaceful settlement, the employees can settle the conflict very fast, and in a lot of cases regarding sensitive information and so on, it's a very good method. Both employees and employers don't know what it is, and they don't recourse to that. I think this is something we have to work on. We have to move in that direction. In many advanced countries, mediation is the first stage before going to trial. I could say many other things, but I wanted to conclude by saying that all these changes are very important. Labor laws have to be reformed, especially considering that we need to leave the economic situation of today behind and to keep the balance of interests, not to make everything too formalized or to make things too difficult for the employee.
And to conclude our discussion, I would like to address Evgeny Reisman and ask about his opinion on how he sees the perspective of the labor law development. Maybe you could add something to the issues that have been voiced. And in general, I would agree with Yulia Vladimirovna, and I would only like to add that our future is probably we need to learn how to compromise. We cannot enforce this or that party in the labor relations. And our French colleagues said, I was impressed by the level of compromise the French managed to achieve, because France is a country with the most developed legislation protecting the workers, protecting employees, and protecting their right for self-protection. And with this level of protection, they managed to reach compromise when both parties realized that it needs to be reached in the current economic situation. And I'm even jealous a bit. When we discuss other changes in the labor law, we probably need to learn how to compromise, the art of compromise. We are not yet developed enough. We'll learn how to do it, and we'll improve our legislation in this sense, and we'll have something to work with. Thank you very much. Dear colleagues, do you have any questions? You can ask them. I have a question, maybe not a question, but a comment. Alexander Perelman, I head the chair of labor law in Moscow University. I work with both employees and employers as a counselor. I'm head of the Committee on Social Legislation, and I work in the State Duma in the Labor Committee as an expert. And I'm a member of the Expert Council of the High Court. So I know it on the tips of my fingers. We know that we have illusions that that Russian economy only suffers from the bad labor legislation, and we hear that it is the root of all evil in Russian economy. I'm neither defending employees or employers, but I'm an expert in the field. But we have this idea that each generation of managers want their new labor code to be written. But like the International Labour Organization says, Russian labor code, the present present Russian labor code is not bad. It shouldn't be an instruction instructing you how to act in every given situation. Like yesterday's Mr. Zorkin said, we shouldn't be talking about economic constitution. We have to be very careful about it. But if we put it in brackets, it's rather constitution than an instruction. They need to have a list of instruction. We shouldn't forget. I mean, nobody wants to change the general provisions of the labor code. Nobody says it should be changed. And you have 55 articles in this general provisions. These are the provisions we should apply. We should apply various legal categories that allow the courts today to apply those norms. And the plenary session, for example, would adopt something that is not in the code. We are more or less we are more certain about the agency work, but I mean, if we think of the crisis of the 1998, we didn't have to deal with the agency work. We didn't, and the sphere of agency work covers a very little scope of employees. So I think we're exaggerating a bit on the speaking too much of the agency work, and as Ms. Karin said, 80% of the people who are employed or labor force of each country are people who actually who are employees. You're all of you, most of you, unless you have your own business, you work using labor contracts. So the majority of problems we face have to deal with the labor code, and I would agree to what Mr. Reisman said. We should seek compromise. I think it was a very valuable comment you made. My name is Alexander Korkin, Pepelev Group company. I have to go to courts 3 times a week, and on one hand, I would support my colleague in the sense that legislation is sometimes even more progressive than other countries' legislation. So our major problem is the application of this legislation. I'm not talking about labor inspections where you often have a very low level of application and the understanding of law is very low. So it's a problem of the courts as well. You have very formalized approach when the judges are either not qualified or don't have time to see into the matter, and they only they reserve their judgment to formal matters. That's why employers want to have all the norms written in the code, because nowadays when you go to court, you're unsure of the outcome because you have to rely on the judges. So the judges their qualification is also of paramount importance. Thank you. I represent the city of Ufa in Bashkortostan, and I'm an educator, and we start mediation in our I'm a deputy chairman of the Mediators Guild in Bashkortostan. We have realized that we need to seek compromise and resolve disputes out of courts, and I have a question to our international guests. What can you tell about about mediation in labor disputes and the development of mediation in labor disputes? What can you tell us about that? How did it develop in your countries? Pascal, could you tell us how does it work in France, mediation in labor disputes?
In France, mediation is compulsory. You have 2 steps. You have a conciliation hearings, and then after that you have a judgment hearing. So for now it's not the conciliation is not working so much. But with this new law, I do not explain all the content of this new law, but with this new law you will have un barème, you will have a range of amount, and which will depend on the seniority of the employee. And during the conciliation hearing you can take it or go to the judgment hearing. And for sure, it will be very risky for the employee who will not take the conciliation hearing, because he could receive less than what will be offered during the conciliation hearing.
So But mediation in France, this is mandatory before the court
Yes,
hearings.
yes,
Okay.
we call it conciliation.
Okay, thank you. Richard, is that the same way you have in UK with the mediation?
No, it's quite different in the UK. So certain types of disputes are dealt with in the high courts, so not the employment-specific area. And in those courts, if you unreasonably refuse to mediate, then you will be penalised in costs if you lose the case. So that is the way the government is attempting to nudge or persuade people without mandating that people should mediate. That is also becoming common in the employment-specific specialist tribunals. And so now, in the first procedural hearing, you have to fill out a form and say, are you prepared to mediate? And if not, why not? And you have to explain that to a judge. And there is a judicial mediation scheme whereby the judges can offer to sit for free as mediators to try and conciliate the dispute. And very much as Pascal was describing, they are very proactive, and they will give a range. They will say, I haven't looked into every fact in this case, but if you won, you'd be likely to get something in this range. And that is meant to promote a more sensible discussion. But it's the fastest growing area of UK employment law, and it's actually through private mediation. So I head the mediation team at my firm, and we do workplace mediations on a whole range of issues, because in the UK, unfortunately, we've become completely mired in process, and the process gets in the way of having meaningful discussions between managers and employees. And so mediation provides a route for people to have sensible, safe, protected conversations. So we call them facilitated discussions.
Спасибо. Нам удалось немножко пытаться ответить на ваш вопрос.
We answered your question. Thank you very much. Thank you, speakers. I would like to thank the speakers who managed to find time to participate in the forum. Thank you for your attention.